Third means that
Edeka.
Edeka, learned counsel for the applicant. None appears for the respondent. Number 1 and 2, though the name of their engaged counsel is reflected in the cause list. This is the matter on Friday. Till then, interim order dated 4/4/2022 shall continue.
Item 38.
Your Lordship, by last order, we were supposed to take steps, issue notice by both ways. Your Lordship, R4 has personally received, and with regards to R1 to R3, the wife of R1 and sister-in-law of R2 and R3 have received the copy. This, Your Lordship, this is with regard to the delayed continuation petition.
Third means
A. Biani.
learned counsel for the applicant. Office note dated 30/7/2024 indicates that service report in respect of respondent number 1, 2, 3, and 4 received. It appears that respondent number for the respondent number 1, 2, and 3, the notices were received by one Srimati Pramila Munda, wife of Gautam Munda, who is the respondent number 1 here in this petition, here in this application. And respondent number 2 and 3 belongs to the same family. And the recipient of the notice, Srimati Pramila Munda, is the sister-in-law of respondent number 2 and 3. It also indicates that respondent number 4 has received the notice personally. And as such, notice appears to be served upon all the respondents, but no one entered appearance till date. List the matter after 1 week, and rest is I'll put up an up-to-date office note indicating whether any learned advocate file an ukalatnama on behalf of respondent number 1, 2, and 1, 2, 3, and 4. Monday? Next Monday.
37.
Your Lordship, as per office note dated 27/7/2024, respondent number 1 appeared, and respondent number 2 and 3 notice answered. Yeah, I may be allowed to take face step upon the respondent number 2 and 3.
Third, Miss
P. Bora.
Learned Counsel for the applicant, and Mr.
KK Bhutto.
K.K. Bhutto, Learned Counsel for the respondent number 1. Ms. Bora submits, no, referring to the office note dated 28/7/2027, Ms. Bora submits that service in respect of service of notice issued to the respondent number 2 returned with a report that no such person is available in the address furnished, and therefore the same has been returned. And in respect of respondent number 3, it is stated that insufficient address. Ms. Bora submits that she will take fresh step upon respondent number 2 and 3. Accordingly, it is provided that Ms. Bora shall take a step upon respondent number 2 and 3 by registered post and also with heady and also by usual process within 2 working days from today. Place the matter after 4 weeks.
3 weeks.
3 weeks.
39,
May it please the Lordship. Lordship, neither ID card nor answer notice in respect of respondent number 1, 2, 4, and 5. And in respect of respondent number 3, Lordship, addressee not found notice has been returned answered.
Third, Ms. M. Soikia, Learned Counsel for the applicant. Office note dated 26/7/2024 indicates that notice issued to the respondent number 1, 2, 4, and 5 has not yet been received back. And the ID cards have also not been returned. And in respect of respondent number 3, and notice issued to the respondent number 3 returned with a report that addressee not found returned to the sender. So you want to take fresh step?
Fresh steps, Lordship, upon respondent number 3. And rest will await service report, Lordship.
Okay. Learned Counsel for the applicant submits that she will take fresh step upon respondent number 3.
Lordship will take to Dusty if possible, respondent number 3.
No, the Learned Counsel for the applicant submits that she may be permitted to cause service of notice upon respondent number 3 by Dusty mode. Here is accordingly allowed. After serving notice upon respondent number 3, Learned Counsel shall file an affidavit before this court. Office note also indicates that ID card in respect of neither ID card nor unserved notice in respect of respondent number 1, 2, 4, and 5 returned to the section. Then accordingly, it is provided that recessal is the matter after 4 weeks.
Yes, Lordship.
Awaiting service report upon respondent number 1, 2, 4, and 5.
item 40,
Lordship, this is a controversy of delay petition for 187 days. Service is complete. I'll honor and appear for respondent number 3, Lordship. Since complete.
You are for respondent number 1.
yes, sir.
Respondent number
Tata
3.
AIG.
Respondent number 3. Respondent number 1.
Respondent 1, Lordship.
1, Lordship. Okay. Explain, Lordship, in
I said file objection, Lordship.
No, that's all right, but it is stated in the office note that Ukalanama is filed for the respondent number 20 also.
1, 2, 8.
Kon- Acha. Part Mr. A.L. Agarwala, learned counsel for the applicant, A.R. Agarwala, learned counsel for the applicant, and Mr. K.K. Bhatto, learned counsel for the respondent, opposite party number 1. None appears for the respondent number 2 and 3. Though the name of one Mr. B. Deuri and Ms. P. Borua is reflected in the cause list. So sort that. If they fail to appear on next day, we will consider your pair. List the matter on Friday. In the event of subsequent non-appearance of the respondent number 2 and 3.
After 2 weeks, let's say. After 2 weeks, after 2 weeks, let's say.
2 weeks.
I have to file objection also.
Acha. The learned counsel for the respondent number 1 submits that he may be granted 2 weeks time so as to enable him to file objection to this petition application. Here is accordingly allowed. This is a list the matter after 2 weeks.
21. In this case, as per official dated 18/7/2024, services completed.
Service
I am
com-
for respondent 1 only.
Heard Mr. Bhatto, learned counsel for the applicant,
Sir Ahmed.
and Mr. Acer Ahmed, learned counsel for the respondent number 1.
1.
Respondent number 1. Order dated 18/7/2024 passed by the Lawazimba Court indicates that notice issued to the respondent number 1 to 3 has not been received back. However, the track consignment report available on the record indicates that notice has been delivered to the addresses. And as such, service is complete for respondent number 1 to 3. But none appears for the respondent number 2 and 3. Place the matter on Friday. Receive on Monday then.
My lord.
42, sorry, yes, 42.
Your Lordship, this IA 1695 is for a delay of 1 day.
What is the ground?
Your Lordship, the appellant insurance company is a PSU. So during the routing of the file, taking opinions from the advocates, it took some time. Your Lordship, we have filed the appeal initially in October 2023 without any condemnation petition. But then when we inquired in the registry, we got to know that there was a defect, that we have not filed the condemnation. There was a delay of 1 day. So accordingly, now we have filed and this matter has come up.
Heard Miss,
A. Biani.
learned counsel for the applicant. This application under Section 5 of the Limitation Act is referred by the applicant, United India Insurance Company Limited, for condemnation of delay of 1 day in preferring connected appeal against the judgment and award dated 19/7/2023 passed by the learned member, Motor Accident Claim Tribunal number 1, Kamrup M, Guwahati in MSc case number 67 of 2016. The learned counsel for the applicant submits that the applicant is a public sector undertaking and in the process of routing the file, delay had occurred and the same is not intentional, rather it is circumstantial, and she has explained the reason of delay in paragraph number.
Your Lordship, 4 to 7, 4 to 8.
Have you correctly mentioned the paragraph number?
Yes or no?
After 4 again 3.
Oh, yeah. So sorry, Your Lordship, there must have been a typographical error.
In paragraph number 4, 5 and 6. 4, 5 and 6. But having heard the submission of learned counsel for the applicant and also considering the facts and circumstances on the record, this court find that the delay of 1 day is explained sufficiently. And therefore, this court is inclined to condemn the same without issuing notice to the respondents. The delay of 1 day in filing the criminal connected appeal is hereby stand condemned. In view of the order passed in this IA, the registrar shall proceed to register the appeal and list the same before the court. And cards
43,
available, this IA is sent to disposal.
43,
Condolence of delay petition, first time lordship, so notice may kindly be issued.
Pardon?
This condolence of delay petition, first time lordship, so notice may kindly be issued.
Heard Mr. Agarwal, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred for condonation of delay of 734 days in preferring MSc appeal. Now, in preferring an appeal against the judgment and award dated 13/8/2021 passed by the learned member Motor Accident Claim Tribunal number 2, Kamrup M, Guwahati in MSc case number 2592 of 2017. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post and also by usual process within a week from today. List after 4 weeks.
44,
Lordship, therefore release of the 50% deposited amount. Lordship. And the lordship, respondent number 1, wife of the deceased may kindly be allowed to the 50% deposit amount without any rider.
Madam, you were for?
Insurance, my lord, the Oriental Insurance Company, my lord, subject to furnish the bond, my lord. Thereafter, they may take. Because they have no learner license, my lord, driving license. That's why, my lord. So subject to furnish bond, my lord. Thereafter, they may take.
Lordship, no problem.
Pardon?
No problem, lordship.
My lord, they
Keep the board, lordship.
subject to furnish bond, my lord, by the claimant, my lord. To withdraw amount, my lord, 50% amount, my lord.
Respondent number 1 may kindly be allowed to subject to bond, lordship.
You executive gone?
While releasing the payment, will execute the bond.
Yeah.
Yes. The waste is also. But respondent number 1, lordship. Wife of the deceased, lordship. Without any rider, lordship.
Sandana Basumotari.
Yes, lordship. She may kindly be allowed to do the amount deposited before the registry, lordship. subject to furnishing of the board.
Heard Mr. Agarwal, learned counsel for the applicant. Stroke claimants. And also heard Madam,
L Sharma,
learned counsel for
on
the
behalf of SK.
respondent, opposite party, Oriental Insurance Company Limited. This application, this interlocutory application is preferred by the applicants for allowing them to withdraw a sum of rupees 5,65,000 deposited by the appellant opposite party, the Oriental Insurance Company Limited, pursuant to order of this court dated 10/7/2017, passed in IA within bracket C number 1619 of 2017, corresponding to MSC appeal number 221 of 2017. Mr. Agarwala, learned counsel for the applicant, submits that the applicant number 1 may be allowed to withdraw the aforesaid amount
Without
Yep.
any rider loss.
without any rider. However, the learned counsel for the respondent stroke opposite party submits that on execution of a bond, the applicants may be allowed to withdraw the aforesaid amount. Whereas having considered the submission of learned advocates of both the parties, it is provided that on executing a bond of equal amount, the applicant number 1 may be allowed to withdraw the amount deposited with the registry of this court.
Yes, Lord.
Yes.
Without any rider.
No, you have executed one bond
To the registry. Lord.
registry.
Through the registry.
To be released to the applicant number 1 without any rider loss.
Obligation.
Much obliged.
45,
Please, your lordship. Lordship, this is a substitution petition, your lordship, for the respondent number 1, who expired on 26/2/2024, your lordship, leaving behind his legal heirs on page 7, para 3, your lordship of the IA.
Where is the certificate?
Lordship, there is an information from the respondent number 1. We got to know about his death from respondent number 1, annexure 1, your lordship. It's an information that we received from them.
Yes,
Lordship. I'm for the respondent number 6 and 7, Lordship.
respondent number 6 and 7.
Lordship, Lordship.
And
Yeah.
you are?
So I have for the respondent number 1, 2, 3, 4 and 5.
Heard Miss,
FN Jaman.
learned counsel for the applicant. And also heard Mr.
TR Gogoi, Lordship.
T.R. Gogoi, learned counsel for the respondent number
6 and 7, Lordship.
6 and 7, and Mr.
And Brahma Lordship, appearing on behalf of
M.
Brahma,
Brahma, learned counsel appearing on behalf of
G. Bharadwaj. G. Bharadwaj,
G. Vardas for the respondent number
1, 2, 3 and 4 and 5
1, 2, 3, and 4.
and 5.
4 and 5. So there are some other respondents also.
The respondent number 8 is railway, Lordship, when of railway.
No, in this application only 7 and 8 are there. General manager and settlement officer Dhuburi.
The in the original petition, RSA number, Lordship, 51, Lordship, sorry. The 6 and 7 are the 6 is the deputy collector, 7 is the settlement officer.
I don't know how they have arrived the parties here.
It was here. Lordship,
Have you
yeah.
checked it with your this
We have
main
not
petition?
We have not received the IA.
They are being made party
Your Lordship. They are being made party, Your Lordship, in the main appeal memo as well. As per order dated 2/3/2020, Your Lordship, 6, 7, and 8 were made party, Your Lordship.
We have not served a higher copy actually.
Okay, if available, serve it. This application under order 22, Rule 4 of the Code of Civil Procedure is preferred by the applicants for substitution of legal heirs on account of date of respondent number 1. The learned counsel for the applicant submits that the respondents have informed via Annexure 1, letter dated 29th May 2024, that respondent number 1, Ms. Mohammad Maizuddin SK, died on 26/2/2024. And on the basis of aforesaid information, this application is preferred for substitution of legal heirs of the respondent number 1. So issue notice to the respondent number 7 and 8. So notice to the respondents. Step be taken upon respondent number 7 and 8 by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 to 6 as they are represented by their engaged counsel. This is the matter after 4 weeks.
46 and 47.
Lordship, there was also an abatement petition, Your Lordship, along with the substitution petition, Your Lordship.
Amendment petition.
Abatement, yes, Your Lordship.
Abatement.
2148 for setting aside abatement.
Okay. Hard Miss so-and-so, learned counsel for the applicant, and also hard Mr. So-and-so, learned counsel for the respondent number 1 to 6. This application under order 22 rule 9, within bracket 2, read with section 151 of the Code of Civil Procedure, is preferred for setting aside the abatement of appeal against respondent number 1 in RSA number 51 of 2020 on the date of respondent number 1, Mohammad Maizuddin SK. Let notice be issued to the respondent number 6 and 7 and 8. Step be taken by registered post and with AD and also by usual process within a week from today. List the matter after 4 weeks.
46, 47.
This was an early hearing application for hearing the regular second appeal, which was filed in the year 2017. We are the respondent in the regular second appeal. And this appeal has a checkered history. The original suit was filed in the year 1984, which was renumbered in the year 1995 by the predecessor of the present applicants and the respondent in the regular second appeal. The suit was decreed in our favor, whereby my right to interest was declared and prayer for recovery of possession from the original defendant in the suit filed in the year 1984 was allowed.
But they filed, the original defendant filed a title appeal against that order in the year 1998, which was dismissed. Then they preferred a regular second appeal, which was also dismissed. Then, my lord, when we filed the application for execution, for executing the decree obtained in the year 1998, but a third party has come, my lord, objecting to the decree by two, my lord, sets of application. One is suit filed against the decree, and another is, my lord, petition under order 21 rule 97. Both this suit and the petition under order rule 21 and rule 97 was dismissed by both the courts below. Now they have come before this honorable court by a regular second appeal, my lord. These applicants are the unmarried daughters of the original plaintiff in the of the suit, my lord, filed in the year 1984. They are the house where they are living, my lord, it's in a very dilapidated condition. Whenever they go ahead with the construction or developing something in the land, my lord, they object. They come and object. Well, third party are there, my lord, involved. Third party.
So that's all right. We'll hear you. So when can it be fixed then?
Any day in the month of September.
Yes,
September.
after 12th of September, any day.
After?
12th of September, any day.
Why such a long date?
And we have some fixed matter in the month of August and September first week also, that is.
The last week of August then.
August. We have some difficulties in the month of August matter.
No, the matter is very old. as
Yes, I
submitted by
understand.
him.
Any day after 12th of August, September, sorry.
No, in the last week of August.
First month. As a 29 bit are fixed. The 3rd of September, madam. Tuesday,
3rd of September, Tuesday.
yes.
Tuesday. Okay, heard Mr. Biswas, learned counsel for the applicant, and also heard Mr. Your good name, please?
SK Chakraborty, ma'am.
SK
Chakraborty, ma'am.
Chakraborty, learned counsel for all the respondent.
No, appellants, madam. In both
No,
the,
in this application,
in this, yes, madam.
all the for the
Opposite party.
respondent opposite parties. This application is referred for early hearing of RSA number 60 of 2017. Mr. Biswas, learned counsel for the applicant, submits that there is urgency in early disposal of the RSA number 60 of 2017, which is pending before this court for last 8 years.
Yes, it's been pending here, my lord, since 7 years.
2017 episode.
And the execution, my lord, was filed in the year 2007. And the decree was obtained in the year 1998.
But having heard the submission of learned advocates of both the parties and also as agreed by them, it is provided that reception is the matter on 3rd of September.
This RSS 60 and 59 are tag matters, my lord. It has, my lord, been filed.
RSA?
59 and 60.
Item 47. madam. In 47, there is already an order for listing the matter for any in usual course.
Well,
RSA 59 of 2017, madam. There is already an.
But all this year, it was only pending for service of notice upon the respondents. Finally, my lord, in the this year, my lord,
For hearing, it's usual course, 10th May.
So there is an order of this court to
my lord,
fix it
that is
in
why,
usual
my lord,
course.
when the order was passed, my lord, there was an indication, my lord, if there is any urgency, and early hearing petition may be filed. So your lordship may take very well of the cognizance of the matter, my lord, considering the fact that the decree was obtained in the year 1998. Though there is an order, my lord, it was an indication from the court, my lord, if there is any urgency to file an appropriate application.
No,
That's why-
but it has not been reflected.
No, it was an indication, but it may not be reflected. But your lordship may independently take the opinion in this present application because considering the facts and circumstances of the case.
Okay, in view of the submission of Mr. Biswas, learned counsel for the applicant, basis shall also list the RSA number
59 of
59 of
2017.
17,
59 of 17 on the same day.
March of the year.
48,
May please be noted. Here in this case, my lord, this sole respondent number, sole respondent died, my lord. We have prepared substitution application, but there is a delay of 1 to 4 days, my lord. So at this stage, my lord, notice may be.
You are for?
I am for the deceased respondent also, to the substituted, they have to notices to be placed.
Heard Mr. R. Sharma, learned counsel for the applicant, and also heard Mr.
A Borua.
A. Barua, learned counsel for the deceased respondent. Okay.
IA, my lord, 2154.
There is another IA, 2154,
Yes, 2154 for delay.
delay.
Condemnation of
This application under section 5 of the Limitation Act is referred by the applicant for condemnation of delay of 1,214 days in filing the application for substitution of legal heirs and representative of the deceased sole respondent, namely Hari Mohan Day in RSA number 18 of 2012. Peruse the application, the documents enclosed with the record. Let notice be issued to the respondent opposite parties, returnable on 4 weeks, returnable in 4 weeks. Step be taken by registered post and also by usual process. Registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
applied.
This IA. Is it necessary to pass order in
My lord,
2153?
in condonation, my lord, I will serve, then, my lord, if they appear, my lord, I will serve the copy of the setting aside abatement as well as. my lord,
Only after condonation of delay. Okay.
49.
May please your lordship. IA 2227 has been filed for striking out the name of respondent number 2, lordship. Is the owner of the vehicle.
Respondent number
Respondent number 2, lordship.
2.
2, lord. Because service could not be, notice could not be served on respondent number 2, lordship. And in the original MSCT case also, ex parte order was passed against.
This IA number 2023.
Yes, 2, 3. Yes, lordship.
This
That
is
for
for condonation of delay,
delay.
471 days.
470
So notices were issued to the respondents.
respondents.
So one is represented by his counsel,
Yes,
by its counsel.
yes,
So respondent name of respondent number 2 is to be strike out.
that's right.
Application to court, itu to
Order dated 15/9/2023, there was a order to file an IM.
Acha. Heard Mr.
S.J. Sharma on behalf of A. Bolwar.
S.J. Sharma, learned counsel appearing on behalf of Mr.
A. Bolwar.
A. Barwa, learned counsel for the applicant, and Mr. K.K. Bhatt, learned counsel for the respondent number 1, respondent opposite party number 1. This application is preferred by the applicant, Srimati Septemi Sangma, for striking out the name of respondent number 2, namely Mr. John Bart Sangma, who was the owner of the vehicle number ML08A dash 0609 within bracket superbus. From the interlocutory application being I number civil number 2023 of 2019. Mr. Sharma, learned counsel for the applicant, appearing for the applicant, submits that. So notice could not be served upon him.
Yes.
Submits that. Notice upon the respondent number 2 could not be served for a long period, despite best effort made by the applicant, and as such, it is submitted that his name may be strike out from the array of this on the array of the application number.
202.
IA certificate C number 2023 of 2019. Yes, any objection?
Already I have filed in the objection in the condemnation petition.
Condemnation petition. Okay. Pero, having heard the submission of learned advocates of both the parties, this court is inclined to allow this petition, and accordingly it is provided that the name of respondent number 2, Mr. John Bart Sangma, shall be strike out from the array of the application number IA numbers IA within bracket C number 2023 of 2019. In terms of above, this IA is then disposed of. Necessary correction may be made in the IA number 2023 of 2019.
Item 51.
I have to take a step, my lord. Due to my bona fide mistake, my lord. Because, my lord, I asked that.
So you have not taken a step as per direction of this
My
court.
lord, the reason is behind that, my lord, I have not ascertained the correct and address, my lord.
Acha. Mr. K.R. Padgiri, learned counsel for the applicant, submits that he could not verify the address of the respondent number 1, and therefore he could not take any step upon him. And therefore, Mr. Padgiri contended that he may be granted some time to take step upon respondent number 1. Pair is accordingly allowed. Recessal is the matter after 4 weeks.
Well,
After 4 weeks.
52.
But in this case, my lord, this honorable permitted to dusty service, my lord. And when I serving, my lord, I came to know that, my lord, the respondent number already died, my lord. But I have not ascertained the date of death of my lord. And it then appeared, my lord,
I am for the respondent
my
number
younger brother.
2, 3, 4, 5, and 6, and 7.
Heard Mr. Padgiri, learned counsel for the
Here, Pati.
appellant, and also heard Mr.
IH Laskar.
I.S. Laskar, learned counsel for the respondent number 1 to 7.
1 to or 2 to 7 years.
1 to?
1 is already expired.
Oh, 2 to 7. 2 to 7. Mr. Padgiri, learned counsel for the appellant, submits that as per his information, respondent number 1 already suffered demise, but he could not ascertain the same, and prays for granting him some time. Here is accordingly allowed. Recessal is the matter after.
Respondent may provide the date of death, my lord, of the and legal years, my lord.
After?
The respondent may
No,
provide the date
no.
of.
How many days?
My lord, 3 weeks, my lord.
3 weeks. It is further provided that the learned counsel for the respondent number 2 to 7 shall provide necessary information to the appellant. Provide it.
Yes.
My lord.
I love you.
Oblige.
53.
None appears for the applicant on call. Recessal is the matter after 1 week.
54.
May I please? Lordship, we have filed this application, Lordship, for release of a check, Lordship. Page 16 may be seen, Lord.
Pardon, Mr. A.T. Sorkar, learned counsel for the applicant, and Mr.
AR Das.
Air,
AR Das.
Air does learned counsel for the respondent number
1 appellant.
1,
1 appellant.
respondent number 1.
He was the appellant, Lord.
Huh?
He was the appellant.
Appellant.
Here opposite party. In application, Lordship, he is opposite party.
Appeal is preferred by the insurance company.
Insurance.
Lordship.
This application is preferred by the applicants. How many applicants?
Lordship, 4 applicants, Lordship.
For 4 applicants.
One is wife and one B and C, Lordship, minor, represented by their mother, 1A, and 1D is the mother of the deceased, Lordship.
By the applicants, namely Kanjila Boru alias Kanjila Brahma, Horihar Boru, Lakshmi Devi Boru, and Miss Nila Boru. For releasing the check amount. Releasing the amount of rupees 15 lakhs deposited by the respondent opposite party before the registry of this court. Pursuant to order dated 26/6/2024 in IA within bracket C number 1951 of 2024. Arising out of MSC appeal number 319 of 2024.
I have no objection.
The learned counsel for the respondent stroke opposite party submits that he has no objection in the event of allowing this application. But accordingly, having heard the submission of learned advocates of both sides and also considering the facts and circumstances on the record, it is provided that the amount deposited with the registry of this court shall be released in favor of the applicant.
Applicant number 1 and
Applicant number 1 and 2.
4.
1 and 4.
Yes, Lordship. May be released to the 1 and 4, Lordship.
1A and 1D.
D. Yes, Lordship.
1A and 1D. As applicant number 1B and C are reportedly minor,
Mine.
represented by applicant number 1A.
Lordship, applicant, we have mentioned applicant number 1, 2, 3, 4. They have mentioned 1A, B, C in appeal, Lordship. And is appellant opposite party, not respondent opposite party, Lordship.
So in this application,
Application number 1
in
and
this
4.
application, he is the respondent.
Lordship.
Yeah, opposite party, yes, Lordship. 1 and 4, applicant number 1 and 4 may be allowed to throw the amount, Lordship.
No, here it is mentioned as 1A, 1B,
Lordship,
1C,
yes,
1D.
Lordship, this is pending in between appellant and respondent.
That's all right. We have to go by the serial number mentioned in this application. No?
We have mentioned page 5, Lordship. This
So
is
what is page number 2 then?
Lordship, it is pending between the appeal, they have mentioned in
No,
appeal.
they are the claimants. They have filed the application.
No, Lordship, this application I have filed. Appeal they have filed.
No, he is representing this insurance company.
Yes, Lordship.
So this amount has to be released in your favor.
Yes,
So you have been arrayed in this petition as A1, AB, AC, and AD.
yes, Lordship, yes. Yes,
So order has to be passed in respect of this applicant. This applicant.
yeah, Lordship, this will, Lordship, but in as a applicant, we have mentioned 1, 2, 3, 4 in page 5.
So
matter.
a respondent. No. So this applicant number 1B and 1C are represented by whom? By mother.
Mother.
as a respondent, no, as applicant number 1B and 1C are reportedly minor represented by applicant number A1, Kanjila Boru alias Kanjila Brown. In terms of above, this IA stands a disposal. Any other matter?
55. 55.
Wait, the lordship. Lordship, this matter has been listed for the first time. Notice has been go, lordship.
Third, Ms. Soikia, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 is preferred for continuation of delay of 68 days in filing filing an appeal under Section 30 of the Employees Compensation Act 1923 against the judgment and order dated 29/1/2024 passed by the learned Labor Commissioner by the Commissioner for Employees Compensation Barpeta in EC case number 183 of 2022. Madam, I could not follow this. What is this? Learned Commissioner.
Learned commissioner, lordship.
Come word is wrongly mentioned here.
Lordship?
This word come.
Oh, that might.
Where is the
wrongly
application?
typed, lordship.
Let notice be issued to the respondents. Returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Please the matter after 4 weeks.
Obliged, lordship.
Item 50 for hearing.
You are for respondent.
Respondent one.
Where is the appellant?
Their absent may be shown, my lord, and one chance may be given by recording their absence. And next date, my lord, if they remain absent,
13 matter.
just 2013 money suit, my lord.
After 13, for the first time, it is listed today.
Yes, my lord, at our mention, my lord.
Acha.
We made mention, my lord.
Who are the
M.K. Sharma is appeared, my lord. The order sheet is there earlier.
AB show today?
Was admitted on 24/2.
Have you seen him in the court today?
No,
AB show today?
no, APCD is no more.
No more. Acha.
His senior is conducting.
Who is
Mr.
junior?
Mr. Sharma, my lord.
Sharma.
Yes, into order, my lord, 24/2, my lord, lordship. At least.
24 to order is not available. 24 to 14.
For
14. 2014.
MK Sharma.
Lord.
Acha.
Lord.
The erstwhile president of your association.
No, another Sharma.
Oh, yeah, MK Sharma. MK
Anna-
Sharma.
Another Sharma.
MK Sharma. None appears for the appellant on call. How about Mr. R. Ali? Learned counsel for the respondent present. List the matter on next Monday, Tuesday.
13.
In the event of subsequent non-appearance, appropriate orders will follow.